Constitution of the Cooperative Republic of Guyana is the supreme law of the land. No such thing as dual citizenship in Guyana. A constitutional crisis or political convenience. Any Guyanese citizen who voluntarily acquires another country's citizenship after May 1966, except through marriage, automatically forfeits their Guyanese citizenship. They are ineligible to vote in Guyana. They are no longer citizens of the Cooperative Republic of Guyana and must not be allowed to vote. A vote by such person will be fraudulent or illegal. The Guyana Elections Commission GECOM has published on their official website their revised list of electors or voters, with the most recent update being August 2025. I have perused the list of my constituency, that is Constituency 3 of District 4, and I have found the names of Guyanese residents of my community who have migrated overseas many years ago and are now foreign citizens of the USA, Canada, and other countries. Nonetheless, these people's names still appear as eligible Guyanese citizen voters on the GECOM revised list of electors. Therefore, it can be concluded that this also applies to all constituencies, thus all 10 districts and regions of Guyana. This illegal act by way of gazette publication by the GECOM is premised on the falsified notion that dual citizenship exists in Guyana. However, the very notion of dual citizenship details the stupidity of our legal minds. The crux of the Constitution: no dual citizenship. The 1980 Constitution speaks. As a social commentator and constitutional analyst, in 2020 and just recently, I did a video where I presented a bold expose of Chapter 4 of Guyana's Constitution into the spotlight. In those presentations, I explained that according to Article 46 of the Guyana's Constitution, any Guyanese citizen who voluntarily acquires another country's citizenship after May 1966, except through marriage, automatically forfeits their Guyanese citizenship. Let me say that again. Any Guyanese citizen who voluntarily acquires another country's citizenship after May 1966, except through marriage, automatically forfeits their Guyanese citizenship. They are ineligible to vote in Guyana. They are no longer citizens of the Cooperative Republic of Guyana and must not be allowed to vote. A vote by such person will make the elections void. Forget the smoke and mirrors in Parliament and the misguiding utterances of the slave master and lying Attorney General Anil Nandlal. Dual citizenship is constitutionally non-existent in Guyana, not just for politicians or parliamentarians, but for everyone. Therefore, all the names of persons, and of course those persons who are currently citizens of foreign nations and still holding Guyanese passports, who have intentions of returning to Guyana to vote in the Guyana elections on September 4th, 2025, your actions, if allowed by the Guyana Immigration Authority and GECOM, will be illegal, which will ultimately nullify the validity and transparency of the elections. This is so because any Guyanese citizen who voluntarily acquires another country's citizenship after May 1966, except through marriage, automatically forfeits their Guyanese citizenship. Furthermore, Article 46 1 and 2 empowers the President of Guyana to strip citizenship from individuals who claim or exercise foreign citizenship rights. Many years ago, there was a great parliamentary misconception with regard to who's unfit to sit the parliament. However, Article 155 of Guyana Constitution disqualified MPs who held citizenship or pledged foreign allegiances. As previously highlighted a number of years ago, the issue isn't just about who's in Parliament, it's who should not be. Article 155 of the Constitution states it very clear. Anyone who acknowledges allegiance to a foreign state is disqualified from serving as a member of Parliament. So why were dual citizens allowed to sit, vote, and pass laws in our National Assembly for years? For 59 years, if they had already relinquished their right to be called Guyanese. Again, the very notion of dual citizenship details the stupidity of our legal minds, and that ignorance of the Constitution of Guyana has now spread far and wide to the point whereby the GECOM has published an official revised list of electors or voters with the names of individuals who are not Guyanese citizens. However, there is a loophole that actually never existed. I say this to say that within the Constitution, there is a provision for reclaiming citizenship. But did any of the MPs follow the law years ago? Or are any of the current process voters whose name appear on the official revised list of electors for the 2025 general and regional elections follow the process? If they did, then where are their letters of application to the Minister of Citizenship asking for their citizenship to be reinstated? On that note, I must say that as per Article 42(2), individuals who relinquish their Guyanese citizenship must formally reapply to regain it. It should be obvious by now that based on the constitutional clauses, the Constitution doesn't magically reinstate your citizenship. That's a legal fiction. Where are the application records? Who authorized these MPs to return to office in the past? And who is authorizing these citizens' names on the official revised list of electors to vote in the September 4th, 2025 elections? There are no documented reapplications and no gazette approvals. Yet the ministers were reinstated automatically, and now GECOM has published a list of names of non-Guyanese, giving them the authority to vote in the elections. Should I say corruption, mayhem, deceit, falsified legal arguments, and or just plain incompetence and stupidity on the part of our legal minds and the administration of GECOM? Where was the presidency on this matter? 1980 to 2025, zero publicized presidential orders of citizenship deprivation, despite numerous known dual nationals in office. From 1980 to 2025, all the presidents of Guyana have been silent on this topic, which clearly details broken oversight and incompetence. This is so because Article 46 requires presidential action to revoke citizenship. Yet, despite multiple public cases of dual citizenship, no official orders were ever issued by any of Guyana's presidents via the Minister of Citizenship, the Ministry of Citizenship, and by way of official legal gazette. This is a clear case of political and executive failure and incompetence by all of our leaders throughout the entire 59 years of our independence. Either way, it's a breach of constitutional duty. Here's my take on this. Guyana's constitution is clear. The silence, confusion, and continued parliamentary failure of oversight of individuals with foreign allegiances point to a systematic erosion of constitutional enforcement, which is reflected today in the GECOM revised list of electors. Whether by ignorance or deliberate inaction, the result is the same: lawlessness from the top down, compounded by ignorance, incompetence, and overwhelming stupidity. In closing, I'll say again that the very utterance of dual citizenship reflects the stupidity of our legal minds. The real tragedy is not just the violation of the Constitution, but the public's normalization of this betrayal. There must be a call to action. I urge all Guyanese to request formal publication of all citizenship reapplications and presidential orders from 1980 to present. The people deserve transparency. The Constitution demands accountability. It is unconstitutional for GECOM to use the current revised list of electors to conduct the 2025 general and regional elections. By doing so, the entire process is automatically fraud, as it has always been for 58 years.